Hello, my name's Tim. I'm a solicitor in the Family Legal Aid Department at Ison Solicitors. Care orders are court orders which give the local authority, that's social services or children's services, parental responsibility for your children. They don't take parental responsibility away from you as a parent, you keep that whilst there's a care order in place. As well as a care order, there should also be a care plan which sets out what the local authority thinks should happen to your children whilst the care order is in place, so who they should live with and whether they should be having contact with the parents as well. There can also be an interim care order made, which is whilst court proceedings are going on. Whether it's an interim care order or a full care order, the legal test, which is called a threshold test, has to be met, which means that the children have to be at risk or suffering physical, sexual, emotional harm or neglect. The local authority make an application to take children into care when they're really worried about the safety and well-being of children. They will make an application to the court and they will try and persuade the court that there are reasonable grounds to believe that the children are at risk of suffering significant harm. That could be physical, emotional, sexual harm or neglect. PLO stands for Public Law Outline, and a PLO meeting is organised by social services when they've got significant worries about the care of your children. They're really a last chance for social services to tell you what they're worried about and for you to try and make some improvements. If improvements can't be made, then social services might take you to court and apply for an order in respect of your children. The hope is that you can see what the concerns are and make improvements, and then social services involvement will hopefully go away in the future. At a PLO meeting, you have the right to legal aid and the right to a solicitor. So if you've got a letter through the post inviting you to one of these meetings, you should contact us. When care proceedings start, the local authority make an application to the court. Sometimes this is done with enough time for you to get some paperwork through the post and for us to discuss it with you. Other times it happens very urgently and we'll have to discuss it with you at court. That will start a process which lasts about 6 months. You should get to see your children in that time. The local authority would have to make a specific application if they thought that you shouldn't see your children in that time, if it was unsafe for any reason. You will have to be ready though for that contact to be supervised or managed in some way if the court think that that's the only way to make it safe for you and the children to have contact together. EPO stands for Emergency Protection Order, and they're only taken out in very urgent circumstances. Therefore, if an EPO has been made, you really need to contact us as soon as possible so that we can urgently find out from social services what's gone on and what their concerns are in respect of your children. There is a similar thing, which is when the police take powers of protection in respect of your children. Again, it's very urgent, there'll be an urgent court hearing and we really need to discuss with you what is going on so that we can help you as fast as we can. When children are in foster care, you should still see your children. If it's an interim order whilst the court proceedings are still going on, then you should see your children quite frequently. The local authority would have to make a specific application to stop you seeing your children altogether if they thought that that was unsafe for any reason. Similarly, when the local authority has a final care order at the end of court proceedings, you should still have contact with your children. The local authority would have to say that it was unsafe for you to not have contact with your children at all. Whilst an interim care order is in place, the child could live with you as the child's parents, alternative carers such as relatives or very close friends once they've been assessed, or the child might be placed in temporary foster care. At the end of court proceedings, if a full care order is made, then again the child could be returned to your care, could be placed with alternative carers or family members, or could be placed into long-term foster care. The last resort, when nothing else will do, is that a child might be placed for adoption. If they're placed for adoption, then once adopted, the child won't have any contact with their birth parent. A care order is only made when the threshold test is crossed, which is the judge decides that there has been or is a risk of your child suffering significant harm. So that could be physical, emotional harm, sexual harm or neglect. The local authority applies to the court for an order, and the court must be satisfied firstly that the threshold test has been met, and secondly that it's proportionate and justified for there to be a legal order in place. It is possible for relatives and even close friends to care for your children within court proceedings and at the end of court proceedings. The local authority will have to carry out an assessment of those people. Firstly, they do a viability assessment, and if that's positive, they will then do a full kinship or alternative carers assessment. So it is possible, but it does take a while for these assessments to be done. The court's first priority is that children should be cared for by their parents, but if that's not possible, they will then look to other family members and alternative carers who might be able to do so. If you've been told by social workers that you're not allowed to see your children anymore, you should really come in and see us so that we can see what the issues are and what the social workers are saying the risk factors are for them. If there is a care order in place, then there should be contact between you and your children. The local authority would need a specific order from the court to stop that contact. It really will depend upon what the specific issues are in your case and how contact can take place safely. If you require any further information, please call 0113 284 5000 or go onto Ison Solicitors website.